Let's get right to it. The Supreme Court ruling on Hobby Lobby. We've got Wall Street Journal's Mary Kissel, former Reagan economic advisor. Art Laffer also is here. And we've got Judge Andrew Napolitano with us as well. I want to start with you, Judge, because I want to talk about the legal aspects of this. What does it all mean?
Which case are we talking about?
Hobby Lobby, I'm sorry.
Okay, the significance of Hobby Lobby is, without getting into the constitutionality of freedom of religion, the court found that a federal statute enacted by the Congress called RFRA, the Religious Freedom Restoration Act, basically says that in order for the Congress to interfere with the religious views of someone, it has to meet a very, very high standard, which the courts call strict scrutiny, compelling state interests served by the least restrictive alternative, and Congress didn't do that here. What does that mean? That means that if you are a sole proprietor, or a shareholder of an S corporation, or a shareholder in a nonprofit, your religious views cannot be trumped by the government's instruction that you provide contraceptive services for your employees. It also means, as Justice Kennedy pointed out in his concurrence, the government can simply pay for those services. This is not to deny women the services. This is to say that the government can't force their employers in those three categories, S-corps, sole proprietors, and nonprofits.
Now, go ahead, Mary.
Judge, wasn't RFRA also important because it was designed specifically to protect minority rights?
Absolutely, absolutely. Justice Kennedy's concurrence is actually has some very flowery languages in there about the obligation of the Congress to protect religious rights from interference by the Congress. And it did so when it enacted RFRA, which was not interfered with by Obamacare. Let me also say it's very significant that the Chief Justice who wrote the decision upholding the constitutionality of Obamacare is with the majority here. He's basically saying, when I signed off on Obamacare, I didn't sign off on this part of it.
All right, let's bring in Art Laffer, because, Art, I want to know what it says about business. You know, this the RFRA Act, there's a part here that says the government shall not substantially burden a person's exercise of religion. You know, one of the big things going on beneath the scenes, gone beyond the religious aspect of this, is the notion that businesses, corporations, that they have rights, that, you know, the whole debate of whether or not they're people or not. This is a major blow to those on the left who really wanted to sort of box in corporations as entities with no rights, and therefore maybe they could be rated or treated differently.
What really gets me here, Charles, if I can, is that it really seems to me to be a pattern that is really that Obama has overreached for a long, long time, and the court now is setting him back. The case I loved was the Illinois case of the healthcare workers, that the unions could not collect dues from non-member healthcare workers working at home. That's another blow to this administration. You know, they've way overreached for way too long, and frankly, the Supreme Court is pulling them back. The only thing I'm really surprised at it was Justice Roberts' decision to allow the Affordable Care Act. But he did it, and I'm glad he did, really, honestly.
Yeah, I mean, Judge, I mean, that gets back to what you were saying, and we had a little bit of this discussion on Friday, the idea maybe, I don't know if Roberts this is a form of a mea culpa or making amends, but it feels like, to Art Laffer's point, since then, the Supreme Court has come down pretty hard on what a lot of people are viewing as an imperialistic presidency.
Yes, it has. Look, it's a 9-0 against the federal as well as state police to look at your cell phone without a warrant. It's 9-0 against the president making his so-called during recess appointments. It's now 5-4 saying you substantially overreached with respect to religious liberties. Look, the left really wanted this court to say corporations don't have religious liberties.
But it's important to say, that does the corporate form really matter? You don't give up your religious rights or your rights as a minority in America.
You're absolutely
at all.
correct.
I mean, can the government compel a Jewish deli not to be kosher?
No.
I mean, that's really what we're talking about here.
Right, and it's about time we had that religious freedom reinforced by the court. It doesn't matter if it's a 5-4 majority. It would have been nice if it was unanimous. It was not unanimous.
It was not.
Dissenters were bitter and biting.
It should have been unanimous.
All right, real quick.
Yeah, the other one is the decision in Illinois on the healthcare workers is really a huge blow to the unions and to the Obama position as well.
Yeah, it is. You know, and one
I mean, I think that's much bigger than the Hobby Lobby stuff, to be honest with you.
We'll see about that, but, I mean, it is huge. I mean, this is another blow against collective bargaining and unions.
Well,
it is.
You know, the Illinois case, the government's position, I agree with Arthur, the government's position was really absurd. This lady, Mrs. Harris, was providing health care for her son, who's permanently disabled, and she was being compensated by Medicare in order to do it. And the government said, you're compensated by Medicare, you're an employee. You're an employee in Illinois, you join a labor union. You join a labor union, you pay the dues. And she said, well, this is insane. I'm staying in the house taking care of my kid, and the feds are paying the bills.
But, they have to do that, Judge. They got to do it, because if the unions can't compel people to pay fees, they know that when workers have a choice,
we're seeing
the union membership goes down.
I want to ask you, though, Mary, and I mean, you were pretty upset that this wasn't the Hobby Lobby wasn't 9-0. But what about those who are saying this is discrimination against women? And this opens the door up to all forms of discrimination. That's what you were hearing on the other side coming into this case. Yeah,
that's absurd. This has nothing to do with public health or gender equality. This had to do with government compelling private individuals to do something that was against their religious beliefs. It should have been a 9-0 decision under any plain reading of the Constitution or under RFRA, as the judge pointed out. This has absolutely nothing to do with the war on women, although that's what the Democrats will say.
Where do we go from here, Judge, legally?
Well, the government, in the Hobby Lobby case, the government could very well decide to pay for itself the contraceptive services that the employers will no longer have to provide. In fact, I wouldn't be surprised if the new Secretary of HHS, Mrs. Burwell, makes that argument this afternoon. That would take some of the political sting out of the rebuke of the president. But it's really back in the government's court. They certainly can't make the private S-corp, sole proprietor, and nonprofit.
And we should let the audience know that's about 90% of businesses.
Yes, yes, it is.
Yes,
this
and
is
let's see what taxpayers are going to say about that if they say we're going to use your taxpayer money to pay for these services.
Yeah, Art.
Charles, now it's time for the Supreme Court said its say. This is the end of the session. Now it's time for the voters to make their decisions, which will be done in November. And there is a huge, huge movement going here that I think is irresistible.
All right, guys. That was fantastic stuff. Couldn't ask for three better people on the topic.